Well, I believe now that I'm finally live. So thank you everyone for joining me and welcome once again. Happy New Year to everyone. Hopefully you guys had the time to enjoy and relax and recharge some of the batteries over the holidays. So what are we here to do? Well, for those joining us for the first time, this is your employment law session. My name is Lior Samfiru. I'm one of the founding partners of Samfiru, Tumarkin, LLP. We operate in Ontario, BC, and Alberta. We're the biggest employment law firm in the country, and I am here on this session like I do every week to talk about your workplace rights, to tell you what you need to know, to answer your questions. If you have a workplace issue, a workplace question, you have the best opportunity that I can think of to ask that question right now. Maybe you lost your job and you want to know what your rights are. Maybe there's a vaccine mandate at your workplace. Is that legal? What can you do about it? Is your employer giving you an ultimatum? Are you suspended? Put on a leave? Whatever the issue, now is the time. Ask the question. I'm going to start. A lot of questions are coming in. I'm going to start answering them in about 20 seconds. So ask yours as well. But let me give you some other contact information. If you want to learn more about employment law, or if you want to connect with me and my team off social media, very easy to do that. To have a private chat, all you do is you go to employmentlawyer.ca. You see the address on the screen below me. Employmentlawyer.ca is that address. By going there, you'll be able to connect with me, get all the contact information that you need, phone number, email, it's all there. So that's your best place to go to. We're going to be here for 30 minutes, but I'm not going anywhere after that. Just go to employmentlawyer.ca. So thank you for joining me. Again, I'm Lior Samfiru. This is your employment law session. Ask your question. You have that opportunity. I'm going to start answering questions right now. First question of the day. First question of the year. What an honor. From Joey on YouTube. If I sue my employer for severance pay, can they also be sued for legal fees? So absolutely. So the way that this works, loser pays winner's legal fees. And in every settlement, keep in mind 99.9% of cases are resolved, and usually very quickly. Yes, we negotiate compensation for your legal fees as well. That's a standard thing. It's in every single case. It's not a unique thing. It's not that in some cases it's part of it, in other cases it's not. In every case, we're going to deal with legal fees, okay? So very good question, Joey. If you lost your job, if you're owed compensation, if you want to know what you're owed, contact me right away, employmentlawyer.ca. Next question comes from Kelly. Let's see. If I'm on a leave without pay, would I still have the option to return to work if I took severance? Is there a time limit to collect severance? So no. Kelly, you have to make a decision. The decision is, do you sit at home and wait to be called back to work? That's option one. You could be waiting months and months if they're going to call you back at all. Option number two is you can treat that leave as a termination and get severance. Obviously, if you do that, then your employment has been terminated. You're not going to go back to work. You're just going to get severance. So those are the options. Some people may want to wait. Other people may say, I'm not waiting. I need compensation now. I can't just be off work. So I want my severance and move on. If that's what you want to do, Kelly or anyone else, you want to contact me as soon as possible. And you have 2 years from when the layoff happened or the leave happened or from when you were let go to pursue your severance. 2 years. Okay. Let's see. Next question from Facebook comes from Amy. Can the government actually stop people from collecting EI if they have been let go due to the COVID policy? They can, but will that happen? No. We'll be able to help you get EI if in fact you're also owed severance. So if your employer, but to do that, we would have to treat your employment as being terminated. If you simply are put on a leave and you don't want to treat that as a termination, if you're denied EI at that point, we can't help. But if you want to treat that as a termination and get severance, we can get you a new record of employment from your employer so that you can get EI as well, okay? In most cases, you'll be able to get EI, but we're going to have to get involved for that to happen. So hopefully that answers the question. Again, for those joining us, my name is Lior Samfiru. I'm the employment lawyer, and I am here live right now as you hear me talk, answering your questions, telling you what you need to know about your workplace rights. So ask the question. How can I answer your question if you don't ask the question? And of course, as I said, to connect with me off air, employmentlawyer.ca. Again, employmentlawyer.ca to get all the contact information, to send me an email, to pick up the phone and call me. It's all there. Okay, let's see. Next question is from Tara. I lost my job as I wouldn't wear a mask. Anything I can do? Unfortunately not. Because there's a government mandate, you have to wear a mask unless you have a medical reason. If you have a medical reason and you provided your employer with a doctor's note, if they were able to accommodate you but chose not to, then you may have a case. But you need something from a doctor in writing that you gave your employer before you were let go. Okay? But in most cases, if you don't wear a mask, because your employer doesn't have a choice, it's not up to them to decide whether you wear a mask. The government says you have to. If you choose not to, you are let go. You're not going to be able to do anything when it comes to masks. Next question from Pear. I think it's Pear on YouTube. How can an employer's vaccination policy override every human rights policy? It cannot. Okay, absolutely cannot. Next question is from Christine Goulet on Facebook. If after a number of years of service you are terminated, does it have any impact your pension entitlements? Well, yes, it could. So your pension accrues as you continue working. So obviously, if you lost your job, your employer is not going to pay into your pension beyond a certain period of time. So that's true. But the money that's in the pension is yours. It doesn't go anywhere. You can take that money and you can either keep it in the pension or you can transfer it to another financial vehicle, an RRSP, for example. But yes, obviously, if you have 30 years of seniority as opposed to 10 years, that's going to impact your pension for sure. Next question we have on YouTube from, again, Joey. Oh, it's Joey's birthday today. Happy birthday. My birthday is in a week from now, from today. Joey, so happy birthday. Next question is from Jay on YouTube. Mandatory weekly testing, is there a way around it in the healthcare field? No, there isn't, because the government has mandated it. So there really isn't a way around it. There's a way around, if you will, vaccination, because in most cases it's not mandated, but testing is mandated. So no, there's no way around it. Next question, good question from Michelle on YouTube. Is there a calculation that we can use to predict potential severance? I'm going to tell you exactly how you can find out right now, Michelle and everyone, how much severance you are owed. Very simple. So write down a pen and paper. Here's what you do. All you do is you go to pocketemploymentlawyer.ca. You see that address behind me? I'll read it to you again. Pocketemploymentlawyer.ca. Pocketemploymentlawyer.ca. We have our severance calculator tool there. That's exactly what you're looking for. When you click on the severance calculator, it's going to ask you 3 questions: your job, the length of your employment, and your age. And it's going to assess how much severance you're owed. Maybe it's 6 months, maybe it's 24 months, maybe it's something else. So that's what you do. If you lost your job, if you're worried about losing your job, if you're just curious about how much severance you are owed, that is the place you go to. You grab your smartphone, your tablet, your desktop, whatever you want, anywhere there's a browser, and you go to pocketemploymentlawyer.ca. There's a number of things you can do there. One of them is our severance calculator. Okay, find out in seconds, free and anonymous, completely anonymous, no names, no credit cards, nothing, how much severance you're owed. And there's also a button there that you can use to contact me directly if you want to. So pocketemploymentlawyer.ca. Thank you for that, Michelle. Good timing on that. Next question is from Fareed, I believe. I'm sorry if I'm mispronouncing this, Fareed, on Facebook. I'm going to be suspended from my job in a few weeks for not having the vaccine. I work for a company that's unionized and they won't help me. I will eventually be terminated. I'm a PSW and I work in a group home. So, Fareed, the only one that's allowed to help you is your union. A unionized employee cannot do anything on their own. A unionized employee cannot hire a lawyer like me. It has to be the union. And if the union won't help you, unfortunately, you don't have many options. You can file a complaint against the union with the labor board. It's called a duty of fair representation complaint. those are not usually successful. That's the problem with being unionized. I've been getting that question thousands of times over the past 6 months. What do I do if the union doesn't support me? You don't have many options. That's the problem, again, with being unionized. So pretty much everything I talk about on these sessions, or if you see me on TV, on radio, everything I talk about only applies to non-union employees. Everything only applies to non-union. If you're part of a union, only one you can talk to, the only one that can help you is your union. Let's see. Next question is from Tricky Dicky. I love that, on YouTube. Starting in March 2020, I worked 121 days in a row without overtime. Can I go after my employer for overtime? Is there a time limit? Yes, you can. There's 2 years. So that time limit will expire or start expiring in March of this year. So you can contact me. Happy to help you and talk about how we do that. But again, you have 2 years from when overtime was earned. Next question is from Michelle on Facebook. What are we to do if we are put on an unpaid leave of absence and have a non-compete clause and cannot take other employment? Can we work elsewhere if we're not paid? So depending on your in any province, the reality is, and for most people, a non-compete is non-enforceable, okay? Unless you're an executive, CEO, president, unless you're an executive, it's not going to be enforceable. So yes, you can work somewhere else, but I think we're kind of putting the cart before the horse there. What I mean by that is, if you've been put on an unpaid leave, you can simply treat that leave as a termination and get severance. So that could pay you for months and months, depending on how long you've worked there. That could be 2 years pay. So if you want to talk about that, yes, let's talk about that. Contact me. You can work somewhere else. Now, if you want to know for sure if your non-compete is enforceable or not, I need to see it, of course. You can contact me through employmentlawyer.ca. You see that address below me right now, employmentlawyer.ca. Let's see. Continuing again, Lior Samfiru, that's me. Questions is what I'm answering right now about employment law, about workplace rights. Ask your questions. We still have some time. Let's see. Next question. Okay, Michelle, I think I answered that in terms of when to contact a lawyer. You should contact me if you are put on a leave. Certainly if you're let go, but if you're put on a leave. There's no need to contact me, if the leave is a month from now, because I can't do anything in the meantime. But once you are actually put on a leave or let go, contact me right away. Okay, next question is from Amy on Facebook. From what I understand, your severance package is also based off of how long you remain unemployed after termination. Does that mean you cannot collect settlement right away? No, not at all. In most cases, settle very, very quickly. You could be owed 24 months pay and you can resolve it within two weeks or 3 weeks. So no, you don't have to worry about that. In the vast majority of cases, we can resolve these matters very, very, very quickly, and you can get paid very quickly. Next question is from Michelle on Facebook. I took the vaccine but did not want to. Now I'm back to work and they will be mandating the 3rd dose. I work in a retirement home. So if you're not part of a union, it's ultimately your decision as to what you do. Keep in mind, if they tell you to get the 3rd dose and you don't, they will likely let you go or suspend you. There's nothing you can do to physically stop your employer from doing that. Okay, they will let you go or suspend you. You will be owed severance. You will be owed potentially other damages as well. But the first thing that you have to decide, Michelle, is are you willing to lose your job? Because you will lose it, right? There's nothing that I can do or anyone can do to stop your employer from letting you go. So if you are not willing to lose your job, the only recourse is to get the shot that they're asking you to get. If you are willing to, then yes, you're owed compensation and I can help you get that. So you need to contact me as soon as something happens to your employment status. Of course, this assumes that you are not part of a union. Right. Next question is from Enrique on YouTube. If let go because of not taking the vaccine, what happens to deferred compensation? Any amounts owing to you to the date of termination, even a bit beyond that, have to be paid. So obviously, I would need to know what is owed, what are the terms, is there a plan, is there a contract? I will have to review all that. But your employer doesn't get to avoid paying you what they owe you just because they let you go. Michelle Krupa, can we be forced to sign a new employment contract so that they can include vaccination as a requirement? Well, you can never be forced to do anything. Your employer can't grab your arm, throw a pen in there, and make you sign. Ultimately, you have to decide what you do. Keep in mind, an employer always has the right to let an employee go. They can let you go because you drive a blue car instead of a red car. They can let you go because you don't sign an employment agreement. They would have to pay compensation. They would have to pay severance. So, no, you can't be made to do it, but an employer always has the right to let you go. And if you are let go, as I said, you owe compensation, and I can help you get it. Next question is from Jessica. By the way, another reminder, me, who am I? Lior Samfiru. What do I do? I'm the employment lawyer. And why am I here? I'm here to answer your questions. I'm here to tell you what you need to know about employment law. So if you're watching me right now, listening is great. Listen, but you can also ask your question right now. Write it in. I will try to get to as many as possible before we're done today. So take advantage of that and ask the questions. Next question is from Jessica on Facebook. I was wrongfully terminated with no formal notice. The company I work for was unionized. They're offering me less than what I'm entitled to. Again, if you're unionized, the only thing that you can do is talk to your union, and if the union determines that you're owed more, the union can pursue it. There's nothing that you can do outside of the union. Next question is from James on Facebook. In terms of severance, if the employer lowballs, is the calculation set in stone, or do you have to fight? It is, well, we negotiate. The way to look at this is we negotiate. If your employer is owed, if the employer offers less than what you're owed, we're going to ask for more than what you're owed, and we're going to resolve it somewhere in the range of what you are actually owed. It's a negotiation. That's the way it is, and that's why these matters tend to resolve very, very quickly. So what you don't want to do is you don't want to compromise your negotiating position by going to your employer and offering to accept less than what you're owed, right? That's why we have to get involved. So James, if you lost your job, you know what to do. You have to contact me. I'll be happy to help you. All right, let's see. Next question from Kevin on Facebook. So Kevin says, my employer did not want to change my work hours by half hour to accommodate ongoing doctor's appointments. However, when I returned to work from short-term disability, my doctor requested that I work the first 2 weeks at 5 hours. My employer wanted me to work a shift starting at 10 a.m. rather than my regular time at 7 a.m. Am I obligated to accept that? Well, it's a question of whether or not your employer could accommodate you at your 7 a.m. but chose not to. If they could have accommodated you, they should. If the only way to accommodate your 5 hours is by having you start at 10, then there's not much that you can do about it. So we need to understand why they're doing that, because they have to accommodate you in your position. And your position is one that goes from 7 a.m. onwards. But if it causes them too many problems, if it's not possible, if the only real proper way to accommodate you is to have you start at 10, then that's okay. So we will need to know that. Okay, hopefully that makes sense, Kevin. Next question on Facebook from Mark. If I work as a server in the restaurant industry, should the employer include the ability to make tips in a severance package? Yes, absolutely. So we would have to do a calculation based on your total compensation. So your total compensation includes your salary and whatever you earn from tips. So that has to be included as part of your severance. So that's important to remember that when it comes to severance, it's not just your salary. It's all components of your compensation. So salary, of course, but tips in this case, bonuses, benefits, car allowance if you have that, pension, you name it. If it's part of your compensation, you're owed that. If it's, you simply ask yourself, let's say you're owed 6 months severance. You ask yourself, if I had worked for 6 months, would I have gotten this? If the answer is yes, I would have, then it has to be also included as part of your severance. Hopefully that makes sense, Mark. Let me know if it doesn't. Thanks for that question. Amy on Facebook asks, what impact do mandates have on employees with active or existing WCB claims, including those on medical leave and return to work, and federal mandates? Well, generally speaking, if you're off work, then the mandate won't apply to you. Your employer can't fire you when you're off work if you don't get the vaccine. When you come back to work, if there is a mandate, at that point you would have to show that you've been vaccinated. So the question is very, very simple, actually. It's a question is the mandate your employer's choice, or is someone else making them do it? Someone else usually is the government. If the government says, employer, we don't care what you want, you have to have this employee vaccinated. If that's the case, then there's not much that you can do. If it's the employer's choice, so in other words, the government's not making them do it, they decide to do it, well then, at that point, if you lose your job, you are going to be owed compensation. Let's see. Next question. By the way, you see on the screen, employmentlawyer.ca. I'm here for another 8 or 9 minutes, but when I'm done here, I'm not going anywhere. I'm going to continue answering questions by email, by phone. Just go to employmentlawyer.ca. You can ask your questions. Let's see. From Teresa on Facebook. My husband has been temporarily laid off since the onset of the pandemic. Very little communication from his employer. What action can he take? He still has benefits. Is he entitled to severance? Yes, so in fact, Teresa, your husband could have, even back at the beginning of the pandemic, he could have treated that layoff as a termination of his employment. He can do it now. And I'm going to say this, enough is enough. Enough is enough. If he has been off on layoff for almost 2 years now, let's call it what it is. It's a termination. Let's get him severance. Otherwise, he's going to continue waiting at home for nothing, God knows for how much longer. So yes, he can treat that as a termination. We would need to get involved, but honestly, it's not complicated. It's not difficult. It's not long. So please have him contact us as soon as possible. Again, employmentlawyer.ca. Anytime I say contact me, what I mean is you go to employmentlawyer.ca and we connect that way. So Kathy, you have a bit of a long question. I think the best way to deal with that, Kathy, is to send me an email or contact me online through employmentlawyer.ca. It's a bit too long for me to read right now. Next question. Okay. From Amy, I pressed, okay, no, from next question is from Susan, actually. My company laid a number of us off at the beginning of the pandemic. Their letter said they terminated everyone and are taking away seniority. So again, as long as you're not part of a union, they owe severance. It's if they've terminated, they have to pay you severance. It's very different if you're part of a union. You have to talk to your union. So what you need to do, Susan, if that's what happened to you, you and your colleagues need to contact me as soon as possible through employmentlawyer.ca so that we can make sure that you get what you're owed. From Carol, I work for a federally, regulated courier company and work from home full time. I have not attested to my vaccine status. We've been advised that we will be placed on unpaid leave on January the 10th. I want to treat it as a wrongful or constructive dismissal. I don't know what to do. I can't find a lawyer in New Brunswick. Unfortunately, you have to, the only one that can help you is a lawyer. And I don't operate, my office doesn't operate in New Brunswick. We only operate in Ontario, BC, and Alberta. So unfortunately, you have to find a lawyer. There's nothing that I can do for you. I can't help you in New Brunswick. Michelle on YouTube. Is there a way to hold the company liable for adverse events caused by the vaccine if they coerce us into getting it and the government and drug company have no liability? So no, you can't hold your employer liable, but you could hold the government. The government may have liability that approved the vaccine. And remember, your employer is not actually coercing you. Here's what I mean by that. Your employer is simply saying, to work here, here's what you need to do. But an employer always is allowed to let you go. Your employer can say, well, to work here, you have to get a Mercedes. Well, that doesn't mean that they're coercing you. They're simply saying that you're not going to work there otherwise, but you'll get severance if you lose your job. So I don't agree with the characterizing this as they're coercing me. Coercing is different. Coercing is when you don't have a choice. When someone puts a gun to your head and you have no choice. This is different. Because the law says an employer can always let you go if they want to, as long as they pay you severance, it's not coercion. Let's see. Next question on YouTube from Gayatri. Sorry if I mispronounced this. My husband was actively recruited from a long-term job of 8 years, and then 10 months later, he was terminated without cause and given 4 weeks severance. Is that enough? No, absolutely not. In fact, when he's recruited away, he's going to be owed even more severance that recognizes his time with the previous company. So you may have only worked for 10 months. The law may consider him to be an employee of 8 years plus because he had 8 years with the previous company. So you could be owed 12 months pay. The other thing I'll say is even if he was only a 10-month employee, he's going to be owed more than 4 weeks. He probably is going to be owed about 4 months pay, even if he's only been there for 10 months. So either way, he's owed more. So Gayatri, what you need to do now, or what your husband needs to do, just contact me and my team as soon as possible. Employmentlawyer.ca. You see that right there below me, employmentlawyer.ca, so that we can help him get what he's owed. Once he signs that, there's nothing that I can do. Okay, so we need to speak as soon as possible. Next question is from Lane on YouTube. Is there a time limit to go after the employer after being put on an unpaid leave? How is it lawful that I cannot collect EI? So first of all, you can collect EI. We just need to help you, and you have 2 years to go after your employer. Let's see. So EI, I've already answered that, Danette, earlier about EI and how that works. I'll take a couple more questions. Next question is from Athena, Loves Life. Good, you should, on YouTube. I'm told my religious exemption request has not been approved. I cited religious discrimination and asked for an accommodation. I was not given any option, and HR is now not writing me back. So the only realistic way to get a religious exemption is if you have a doctor's note, if you have a note from a religious leader in your community, a priest, a minister, a rabbi, whoever the right religious leader in your community. If you have that, and that person says that, yes, for religious reasons, that is part of the religion, you can't or shouldn't get the vaccine, then if they don't accommodate, that's a human rights violation. Simply saying, well, you have to, it's my religious belief, so you take my word for it, that's not enough for a religious exemption. But Athena, the real issue is not even about religious exemption, is are you put on a layoff now or on a leave, or have you been let go? If any of those things apply to you, you're owed compensation, regardless of any religious exemption. So you have to contact me right away so we can get that compensation and also get you EI. So Athena, you want to contact me as soon as possible through employmentlawyer.ca. JC204X on YouTube. What happens when an employer doesn't have the financial means to pay any severance that is ordered? Well, they have to pay it. Now, you're able to enforce against assets they have, against accounts receivable. So unless they're literally bankrupt, they're going to have to find a way to pay it. And you have all these recourse. They may own equipment, right? Machines. You can enforce against that. They may own property. So it's not as simple as say, well, we don't have money. Okay. Now, if they're actually in formal bankruptcy proceedings, you're not going to get paid. But if they're not, yeah, you're going to get paid. You may need my help, but you will get paid. Next question, be the last one today from Jenny. Terminated as of last week for not complying with the vaccine mandate. They're extending my payroll benefits until the end of February. Do I have to wait until then to go for severance? Not at all. You absolutely can't and shouldn't wait. You have to contact me as soon as possible. I would contact me today, Jenny. Actually, waiting here is not going to be in your interest. So to contact me, easy, employmentlawyer.ca. Again, employmentlawyer.ca. Guys, that's the time that we have for today. But I know there's more questions. Okay, I'll try to get to them online and answer them later. But if you still want to talk, if you have questions, there's things that we didn't cover that you want to know, easy. Just contact me through employmentlawyer.ca. Again, employmentlawyer.ca. My colleague Sandy is going to be here on Thursday, tomorrow, answering more questions. But don't even wait until then. Go to employmentlawyer.ca, send an email from there, get a phone number, make a call. There's a form you can complete. It's all there for you to do. Again, my name is Lior Samfiru. I'm the employment lawyer. I'm a partner at Samfiru, Tumarkin, LLP. Thank you very much for joining me today. Happy New Year to everyone. This is our first session. We'll have many, many more of these. I wish you all a good, happy, and healthy year, and we'll talk